again for coming to Legal 101 for early stage founders in partnership with Savvy Legal, which you'll hear about in a little bit. But first, we just want to give a little intro to Start Out in case any of you are new or this is your first event. So Start Out is a nonprofit organization with a mission to accelerate the growth of the LGBTQ plus community to drive economic empowerment so that every LGBTQ plus entrepreneur has the access to lead, succeed, and shape the workforce of the future. A little bit about the programs that we offer. So we have the only LGBTQ plus specific accelerator, and the 56 graduated companies have raised over $750 million in funding. We also have a mentorship program. We have expert office hours. We have an access to capital program with an investor network of about 300 investors who receive deal flow from our founders. We also do events like these all year round, about 50 events per year, and have a community through our network queue where folks can meet each other and connect that way as well. We also just wanted to say a quick thank you to our sponsors who help us put on events like these all year round. We really appreciate their support. And we wanted to quickly shout out that on May 11th, we will be having our next signature event. That's the Start Out Demo Day. It will be from 7:30 to 9, and 8 founders from our community will be pitching for a panel of investor judges. So if that's of interest, you can register on our Eventbrite. We would love to see you there. And just some housekeeping about Zoom before I hand it off to Cindy, our moderator for tonight, to introduce herself. We have both the chat and the Q&A, but if you have specific questions you would like Dan to ask or answer, we ask that you put them in the Q&A and then just use the chat to connect with each other so that Cindy can keep on top of them. And yeah, it should be a really great discussion this evening. So without further ado, I'm going to pass it off to Cindy Lamar, our moderator for this evening. She is also a transformation coach and consultant at Magento Consulting. So, hey, Cindy, thanks for joining tonight.
Hey there, Kayla. Thank you so much. And yeah, I'm really excited to be here. I was part of the San Francisco programming board until I moved. And basically with my coaching, I help people who want to live full lives and reach their career goals, but need a little bit of a thinking partner and some well-being practices to get there. So I'd like to bring on Dan, who is our special guest, our main guest, our only guest, our fireside chatter. And he's going to introduce himself, and then we're going to jump right into some questions that we have prepared and leave time for some questions from you, our audience. So Dan, please tell us a little bit about yourself and your business and why you wanted to do this talk.
Awesome. Yeah, really excited to be here. Really excited to work with Start Out. Love what you guys are doing over there, and excited to be a part of the community. A little bit about background about my experience and my career. So I am a corporate attorney and a founder. So I went to law school, University of Chicago, and then got an advanced law degree specifically in law and entrepreneurship. It's always been a passion of mine. Went and worked in-house at a venture fund. I was fund counsel for over 3 years. So I know what it's like from the investor's perspective. I know what they're thinking about, the legal things that they have on their mind. So I did that for a little while. And then I worked at a big international law firm just doing a high volume of corporate legal work for startups. So worked both company side and fund side. Did that for about 7 or 8 years, worked with hundreds of startups on hundreds of financings, did probably thousands of entity formations. And then I left that to start my own legal tech company. So Savvy Legal is a platform that provides tools to other startups to allow you to take care of the legal housekeeping of your businesses as you're growing them. And so I started that. And so I know what it's like to also be a founder. I know what it's like to have to go raise money, the types of stresses that you go through as a founder. And so that's my background. That's why I feel like I'm qualified to speak about entity formation, legal 101, all of that sort of stuff with other entrepreneurs.
Wow, that's fantastic. And we're so happy to have you because I know all of our founders have had some questions at some point or have questions now that would be great to have answered. And it's important to catch things before they fall, right? You don't want to go too far down the road, the wrong road, and then realize, hey, if only I had done this and that. So we're going to jump right in. And starting at the beginning, what advice do you have for founders looking to incorporate their businesses, and where should they look for information?
Great question. So just super high level advice that I try to give pretty much any founder who's going down this, starting to go down the path of forming a business, their entrepreneurial journey. What I try to tell people is keep things as simple as possible. Don't try to get overly creative, because oftentimes on the legal side of things, where you find that investors get most turned off is when you have somebody, a founder, who says, you know what, Mark Zuckerberg did things this way, very creative approach. I want to do it like that as well. And so I'm going to take a non-standard approach to my cap table, or I'm going to take a non-standard approach to how I hire employees. That is all well and great if you're Mark Zuckerberg. But for most of us, we're going to be talking to investors from a position not of leverage like Mark Zuckerberg had when he was raising money for Facebook, but of vulnerability, and trying to convince the investors that our team and our product and our technology and our business plan are awesome. And the last thing that you want from a legal perspective is for your legal creative approaches to things to distract from those things that are actually what make you unique, your team, your ideas. And so from a legal perspective, keep things as simple as possible, as standard as possible. That's kind of the highest level advice that I give. In terms of where can you go for good legal advice, there are actually a lot of good sources out there, but there are a lot of bad sources of legal advice out there. And the places you want to steer clear of are places that are not focused on startups. Okay, for example, LegalZoom is a great legal tech company for mom and pop shops, for people who are starting a plumbing business, or just an all-around SMB type of legal platform. But their education, their advice, their documents are not geared towards high growth businesses. So most startups, your plan is to start small, be efficient, but grow fast, as fast as you can, aiming for that big exit event. And so you want to make sure that the advice you're getting are from people who understand that the legal templates that you're using have been vetted for those purposes. And so, like I said, LegalZoom, a great legal tech platform for the consumer, but not necessarily for entrepreneurs, for startups, for high growth businesses. And so there are a number of well-known law firms out there who have made templates available for free, or advice and education available for free. Cooley is a well-known law firm. They have some content out there under a brand called Cooley Go. And it's a great place to start from a startup compared to, let's say, LegalZoom. So those are the types of places you want to use as the sources of your information when you're trying to educate yourself about legal questions in the startup world.
That's great information. I'm going to go to the second question, and then I'd actually like to take the question from the Q&A because it seems very apropos. So the second question on our list is, when is the best time to form an entity, and what type should I form?
Great, and you're right. This does fit right in with this question, which the question said, we started our company as an LLC. We're curious about switching to an S Corp or C Corp. And I can type in the name of that resource, by the way. There's another question that popped up. But
oh yeah, that would be great.
All right, so types of entities, when to form an entity, where to form an entity. These are great questions. And when the question of when to form an entity, there are usually 4 trigger events that I like to tell people, hey, if any of these events is describing what you're going through, then you're probably at the point where you need to form your entity. So the 4 trigger events are often you're starting to sign contracts where you're selling a product or selling a service to somebody. At that point, you want to have an entity in place to provide the liability protection that entities provide. Corporation, LLC, they both provide this protection. The next trigger event is, are you starting to bring in money? A lot of times people, they're out there, they're starting to get people willing to pay them. Well, how do they pay you? You want to make sure that they're you're getting that money into a bank account that is tied to your business, not your personal bank account. So if you're starting to bring money in from in revenue, you want to have your entity formed with an EIN and a bank account that is tied to that entity. That's going to keep your accounting as clean as possible. The next trigger event might be you're looking at bringing money in from investors. You need to have an entity formed before investors will want to invest in you, because they want to know that the money they give you is going towards the business, not towards your house payment. So that's kind of another trigger event. And then the last one is if you're starting to bring on co-founders, bring on other team members, and they want equity, they want a piece, they want ownership of what they're contributing to, or you want to incentivize them to work hard, you need to have an entity formed so that you can give them ownership in that entity. So those are the 4 trigger events to know when you should be forming your entity. In terms of what type of entity, this is where this Q&A, this first Q&A question kind of comes into place. So there's two places where entity types pop up. There's the state filing, where you are incorporating your business with the state. So you're making a filing, and as soon as that filing is processed, you actually have a legal entity that exists. There are 2 types of entities that you can file or incorporate, that you can form as. The first is corporation, and the second is an LLC. These are the 2 primary types of entities at the state level. You will also often hear the terms C Corp and S Corp or partnership. These are your tax status. So when you form your entity, you're not forming an S Corp or a C Corp, you're forming a corporation or an LLC. When you go to elect how you will be taxed, that's where S Corp and C Corp come into play. So let's talk about a little bit about the differences here. First of all, let me get questions out of the way about if you are planning on raising money from VCs. They will almost universally require that you be a C Corp. So C Corp is a tax structure where you're formed as a corporation with the state, and you're defaulted to this C Corp's tax status, where there are 2 levels of taxation. So if your company is making a lot of money, you might end up paying taxes twice. Now, a lot of founders say, well, if I have to pay taxes twice, why would I ever do that? It's because that double taxation usually actually doesn't apply to most startups, because in order to pay taxes twice, you have to have a profitable business where your profit at the business level, that's the first level. And then you also have to distribute those profits out to stockholders. And then those stockholders pay taxes on those dividends. So that's the second level of taxes. So startups usually don't have to worry about this for 2 reasons. First of all, you're usually growing so fast, you're raising money and spending money so much that you're usually not a profitable business. If you have money to spend, you're going to find a way to spend it. So you usually don't have any surplus. You don't have income in excess of your expenses. So especially if you're raising money from investors, then you have more money to spend than the money you've brought in through revenue. And so you usually actually are operating at a taxable loss. And so that first level of taxation, usually not a concern for startups. The second level of taxation on the dividends, most startups don't give out dividends. And so this C Corp is, for investors, the most common structure. For them, it's all about, they don't want to ever have to pay taxes on your success until they sell their stock. And that's what the C Corp gives you. Stockholders never pay taxes unless there's a dividend. So most investors will require you to be a C Corp. Now, these other two structures, the LLC taxed as a partnership or an S Corp, where do those fit in? An S Corp is something that most startups will never be, for one simple reason, and that reason is that an S Corp is limited to the types of stockholders they can have, and they cannot usually raise money from investors. So if you're planning on raising money from investors, an S Corp is out the door. S Corps are usually used for consulting businesses, services-based businesses like dental offices or farms, those types of businesses. So for Abby, you're asking, okay, I formed as an LLC, I might consider switching to a C Corp. Well, if you're planning on raising from an investor, you probably will need to switch to a C Corp. Where is an LLC appropriate? Those are more appropriate to scenarios where you aren't going to ever raise money from VCs. It's going to be a closely held business. So like a family business that you and your significant other or your parents or your children are going to run, or your siblings. So those are what LLCs are for. You're not planning on selling the business off at some point. The other reason why C Corps are really attractive to founders, despite this double taxation thing that a lot of accountants get hung up on, C Corps allow for a tax treatment of your stock called qualified small business stock. It's Rule 1202 of the tax code, which states that if you hold qualified small business stock for 5 years and then you sell it, you don't have to pay any capital gains taxes on it. So that's only available to C Corps. It's only available to qualified small businesses, which are pretty much startups in the tech and product space. So e-commerce businesses qualify as well. It's not available to services businesses like those dental offices we just talked about. So if you are going to be planning on selling your company at some point, the C Corp gives you access to this tax rule, Rule 1202, and it's potentially a lot of tax savings. So I'm going to mention it briefly. We don't have a lot of time, but you can Google it. I'll type it here for those who do want to Google it. Qualified small business stock, Rule 1202. It's if you have qualified small business stock, you hold it for 5 years and you sell it, you don't pay taxes on the first 10 million on capital gains. So that's potentially $2 or $3 million in taxes that's in your bank account instead of the US Treasury. So that's it's a big motivating factor for forming your business as a C Corp. If you do form as an LLC, and we see this quite often, you see people going and forming as an LLC, is it possible to convert to a C Corp? And the answer is usually yes, depending on what state you formed your LLC in. Some states are more friendly to converting to a C Corp than others. The other factor to consider is you may actually just want to, you formed an LLC, you actually may just want to form a fresh C Corp. It may be cheaper than trying to convert the LLC to a C Corp. There are taxable considerations or tax considerations that may get triggered when you're converting from an LLC to a C Corp that may make that conversion a little bit more painful. The last thing I'll talk about around entity formation is the location where you form your company. Most of you will probably have heard the Delaware Corporation as the recommended state and entity type. And the reason why Delaware is a popular state for formation, and if you're raising money from VCs, oftentimes they'll require you that you be a Delaware corporation. So Delaware is popular because so many companies have incorporated or formed there. Their body of corporate law and business law is completely thought out and fleshed out. There's no questions about how it will be applied. And it may not even be the most business friendly state, But from an investor's perspective, they're willing to take on technology risk, team risk, market risk, industry risk, all these different types of risks, but they're not willing to take on legal risk. And Delaware is the least legal risky state because they have so many companies there that their law, there's no question about how it will be applied. Other states, you're never certain how a judge might apply that state's law because there's not as many companies who have litigated there to establish the body of law there. So the Delaware corporate judicial system is very, very competent, more competent than any other state. Investors just trust it. And so when you're thinking about where to form, if you're planning on raising serious venture capital, you probably need to be formed in Delaware, and you probably need to be a C Corp. Are there scenarios where an LLC may make sense? Yes. Are there scenarios where forming outside of Delaware may make sense? Yes, but they tend to be the exception to the rule.
Wow.
There's one question related to this. I'll go ahead and answer that.
Go for it.
The value or difference of being a B Corp. So a B Corp is essentially a C Corp. B Corps are taxed like a C Corp. The only difference is that a B Corp, from a governance perspective, allows your board of directors to consider the benefit that your B Corp has declared, the public benefit. And so most C Corps, most corporations, the board of directors the only factor that a board of directors can consider when making a decision is, how do I increase stockholder value? They have a fiduciary duty to make their decisions by considering what will increase the stockholder value the most. And so that is how directors are usually making their decisions in corporations. With a B Corp, they are allowed to consider these public benefits that you declare as a B Corp. And so it allows your board of directors a little bit more flexibility. Now, in reality, how does that impact you as the founder? Some investors may like B Corps, and so you might get access to a pool of investors that you otherwise wouldn't. But at the same time, you might close the door on on investors who they're all about profits. They're all about earning more money for their fund. And so if they see you're a B Corp, they might, it might give them a little bit of concern about, how are you making decisions for this company? Are you making decisions in a way that will help me maximize my return on my investment? Or are you making decisions all about that public benefit? And so they're different. There are scenarios where it makes more sense to be a B Corp, and there's scenarios where it doesn't. From the way that you run your business, it's not going to make that big of a difference. You can still consider public benefits as a standard corporation. You can still make decisions that benefit the community. So it's more of a, like you say, it is more of a marketing thing. Most of the B Corps that I've helped form, it doesn't actually impact their ability to raise money. It doesn't benefit them per se. They could have done exactly the same, gotten the exact same returns as a standard corporation, but maybe you do feel a little bit better being a B Corp. So it's kind of up to you. Cindy, let me know if you just want me to continue to kind of run through these Q&A questions. Happy to.
Yeah. I think we'll take a couple more from our list, and then we'll pop back into the Q&A. I think we got a lot covered there in terms of the types of businesses and the differences, and that's fantastic. One quick question about names. So what should founders know when choosing a business name?
Great question. So there's two things to consider when you're choosing a business name. One is, first of all, that's the name that's going to show up on all of your contracts. So you could have a product or a brand that is different from your business name. for example, what we call a DBA, doing business as, you can file to do business as something other than your official entity name. That said, your entity name will show up on contracts. And so usually we recommend that the name of your product or your platform or your app also be the name of your business, because it's just going to be a little bit easier conversation when you're signing contracts with people. They're like, oh, who is this? I don't know who, Be Smart Solutions is. I'm trying to invest in your business, which is not Be Smart Solutions, it's some other name. It's going to potentially confuse people. So ideally, you're picking a business name, which is also going to be the name of your product. But the other thing to consider is that there are trademark implications. And so if you form a business and you go and get a business name that you like, that does not necessarily mean that you're free to operate with that business name. Trademarks and business names are completely different databases. And so somebody could have a business name A, file a trademark on business name B, and they could get it. And so there's no necessarily, they're not necessarily correlated. That said, so with that being said, what you should be doing is go and see if the name you want is available in Delaware. If you're going to form a Delaware corporation, see if you can get that name in Delaware. But then once you've confirmed that, you want to do a trademark search, see if there's a direct overlap with somebody who already has an existing trademark, just to make sure that you aren't going to be preempted after you form your business from actually starting and selling your product under that name. So those are the two factors to consider when you're considering your company name. I'd recommend it be the same as your brand name, and then that you just confirm that there's no trademarks that are currently protecting somebody else's use of that brand name. So those are the two considerations that I'd throw out there.
That's a really important distinction. I think a lot of people might not have known that one. I did not. So That's great to know. How about, what are some of the most common legal mistakes you see founders make, and especially when they're just starting out, and how could they be avoided?
Great question, Cindy. And so one common one, and we've already hit on this with Abby's Q&A, is forming as an LLC when you plan on raising money from venture capital. That is I consider it a mistake, because you end up paying more in the long run to get converted over to a C Corp or to form a fresh new C Corp so that you can raise money. So that's one mistake we've talked about. If you're planning on raising money, probably just do a Delaware corporation from the get-go. The next ones that I often see, there's a number of equity related footfalls or pitfalls, if you will, that I see founders fall into. One of those is, if you have co-founders, you want your co-founders to have what we call a vesting schedule on their equity. Okay, a vesting schedule is a timeline that states, okay, I'm giving you, let's say, 1 million shares, but if you leave the company at any point during this timeline, the company can get back your unvested shares. So that's a vesting schedule. The standard vesting schedule for most founders, or for most stockholders in a startup, is a 4-year vesting schedule. So the stock that you give somebody will vest over the course of 4 years. Usually it vests every month, except for the first year will vest all at once after the first year is up. So we call that a 1-year cliff, 4-year monthly vesting schedule. So that's the standard for, if you're going to issue equity to co-founders, you want to put in place a vesting schedule to protect your cap table. The last thing you want is to go and give a big chunk of your company to somebody who, it turns out, is a bad culture fit for the culture you're trying to build, or is not as hard of a worker as you thought they were, or does not have the expertise you thought they had, or they just simply leave you high and dry, don't deliver, or take a job at Google because they're going to get paid insane amounts of money to go do that. And then they say, hey, thanks for that equity you gave me. Go make me rich. Go work hard on this while I hold a fourth or a third or half of your company. That vesting schedule will prevent that from happening, allows you to get the equity back that they don't earn. So that is a very important kind of issue or problem to avoid if you are forming a company. Get your equity issued right from the beginning with vesting schedules. Then tied to that, related to that, is if you do issue stock with vesting, if you yourself are getting stock with vesting, and I usually recommend that you do, even if you are the majority, the largest stockholder, you're the only board member, and you control the company, I recommend that you also have a vesting schedule, because investors are going to want it. But if you do have stock with a vesting schedule, there is a tax filing that you need to make as soon as you get your equity, within 30 days of getting your equity. It's called an 83B election. If you don't make that 83B election, you might have some pretty gnarly tax consequences when your stock starts to vest. And so it's something that you want to, again, if you do have stock with a vesting schedule, this 83B election will protect you from bad tax consequences that come into play as your stock vests. And so it avoids those vesting tax consequences. You and your co-founders and your employees, anybody who has stock with a vesting schedule, should be filing an 83B election. Other potential issues that I see founders make, there is a type of document that you want all of your team members to sign. It goes by a number of different acronyms depending on what lawyer you ask. The most common acronym is a PIIA. So that PIIA stands for Proprietary Information and Inventions Assignment. So basically what it is all of your team members, when they sign this PIIA, they're agreeing to be subject to confidentiality. So it's like an NDA for team members. Plus, it's an IP assignment. So anything they work on for the company is owned by the company. This is one of the key documents that investors are going to ask you for, to make sure that you've done, that you're getting from all of your team members, from the lowliest intern to yourself as a founder. Everybody should be signing one of these. And if you're not, let's say you have somebody who came in, helped work on developing your brand and your marketing materials, and another developer who contributed to code. Well, you go to raise money and your investors say, well, did they sign a PIIA, an IP assignment? And you say, no, I didn't get that done. They're going to say, well, that means you may not even own the logo that you're using as your brand, because you didn't have the person working on your marketing materials assign ownership of what they did for you back to the company. Same with your code. If you didn't have your developers assign their IP back to the company, you may not own it, depending on the relationship with those developers. And so that could be a problem if the relationship with those employees has soured, if you let them go, if they didn't get paid what they thought they deserved. Now you go back to them and say, hey, my investor won't invest in the company unless I get all my former employees to sign one of these. You may not be able to. And so from the get-go, you should be trying to keep everything in order, get people to sign what they need to, do things the standard way, which includes these vesting schedules. And like I said, keep it simple. Don't try to get creative. Just do the things that most startups in these similar situations would do.
Someone wrote a comment, very insightful, thank you. And I agree, that is so much powerful information that can really help people stay out of hot water later and to hold on to their IP and everything else. So thank you for all of that. I have a question on my list that is also kind of asked in a different way within the Q&A, which is, do you have any advice for how founders should choose their legal counsel? And do you know of any LGBTQ plus friendly legal entities or lawyers or particular places to go for our community?
And great question. Legal counsel, like I said, you want to make sure that you're going to an attorney that is specialized in startups. You don't want to go to, cousin Timmy, who got a law degree and is practicing estate law or divorce law or litigation, and have them do your legal work. So you do want to make sure you're focusing and and engaging attorneys who work with startups on a daily basis. So that's criteria number one. The next criteria is the cost of those lawyers. And so there is a wide variety of costs between startup lawyers, corporate startup lawyers, and expensive usually means good, but inexpensive or less expensive than those lawyers doesn't necessarily mean bad. So you might have, so the common, for example, Cooley Go. Cooley Go is a platform that is run by Cooley. Cooley is an international law firm, well known as being very good at working with startups. That said, they're very expensive. They're also very, very LGBT friendly. And so you would be able to find, they would have within that law firm, Cooley has an LGBTQ plus attorney groups that you can ask for. Hey, can I be put in touch with attorneys from this group? And any attorney would be able to Cooley would be able to point you to the head of that committee. They'd be able to work with you to make sure that you get an attorney that is somebody that you want to work with and that has that expertise. That said, Cooley is very expensive, like I said. And so if you're concerned about costs, which most startups are, you may be looking to more of a regional law firm, not necessarily that big international law firm. You might want to go find an attorney that may have previously worked at a firm like Cooley and see if you can find those people now that they've left Cooley, where are they at now? And there's a lot of them out there. In terms of finding attorneys specifically who are friendly to LGBTQ+, I would say talk to advisors and mentors of yours. See if they have recommendations. Most law firms, I'll be honest, most law firms do have diversity committees. This is something that no big law firm out there is going to want a black eye of not being, friendly to diverse communities, especially the LGBTQ+ community. So most big international law firms will have a diversity community and diversity committee that you can reach out to. In terms of smaller and less costly attorneys, you don't often see them specifically calling out, hey, I am LGBTQ+ friendly. It's just they're not focusing on that from a marketing perspective usually, but there will be, I'm trying to think, there are state bars that have LGBTQ+ bar committees that you can look up with wherever you're located, find the state bar's website and reach out to somebody there and say, hey, I'm looking for an LGBTQ+ attorney. And there will be bar groups that are made up of LGBTQ+ attorneys in pretty much any state where you're at. Those bar groups will exist. So that might be a good place to start as well. Do I know of any specific groups where that is a focus of theirs? Not that I'm aware of. Again, I network with a lot of corporate attorneys, and the focus just tends to be on, hey, we're good startup attorneys and we'll work with anybody. But those other the bar communities, and then just if you do want to work with a big law firm, they will be very friendly to any diversity group.
Great stuff. Okay, I have another question here. What are the legal steps founders should consider when getting ready to make their first hires? What safeguards should be in place in case employees need to be let go in the future?
Great question. So whenever you're hiring anybody, you'll often hear companies talk about their offer letters that they give to employees. And as an employee, you're usually expecting an offer letter. Offer letters are not a legal document that I would consider a necessity, unlike the PIIA, which is. An offer letter is more about, hey, here's your offer. Come and work for us. But if you do send an offer letter out, you want that offer letter to state that the employment is at will employment. At will employment is a term that basically says, I can fire you for any reason or no reason, as long as it's not an illegal reason. So illegal reasons would be discrimination. You can't fire somebody based on discrimination, or you shouldn't be able to. If you do, then that person would have a legal claim against you. But if you're getting fired for, or if you want to fire an employee for lack of performance, you can. If you want to fire an employee simply because you're doing away with that position, you can. If you want to fire an employee simply because they don't fit the culture, you can. Again, as long as you're not discriminating based on age, gender, race, or orientation. So you can't fire somebody based on a discriminatory reason, but that at-will employment is something that you want to have in your offer letter to make sure that you're not locked in to a bad employment scenario. Aside from that, make sure all your employees sign PIIAs. And that is pretty much it from like a legal advice perspective on hiring team members. Make sure that at-will employment is clear and get the PIIAs signed. If you are not in California, you can also have employees sign non-competes. California does not allow non-competes, but most states, other states will to some degree. And so you may want to prevent employees, especially key employees who are core to your business strategy, from going and working at competitors. If that's a concern, have people sign a non-compete.
Sounds good. And I think we can pop back into the Q&A if you see any more questions there that you'd like to address. A couple left on our list. I want to make sure I have time for the last one on here, but if you see any in there that—
Yeah, so somebody mentioned here the sole proprietorship, and can I get a bank account for a sole proprietorship? You can, a bank account, but here's we didn't talk about a sole proprietorship when we were talking about types of entities. Sole proprietorship just means you as an individual are operating yourself as a business and you're holding certain business assets. That is not recommended, because if you sell a product that ends up harming somebody, or heaven forbid, killing somebody, that there may be a lawsuit against the business that sold that product. Or if you provide a service that damages somebody, or if somebody gives you their private information and you get hacked, and then there's a security breach and there's a claim of action against you for releasing somebody's private information. These are all potential litigation scenarios where if you're a sole proprietorship, they can sue you individually for everything you own, including your house, your car, everything in your bank account, anything. And if you don't have enough there, then you may have, you'd have to declare bankruptcy, and there may be lasting effects for that. So sole proprietorships are bad news for business owners in that regard. You might as well just go ahead and form an LLC. Doesn't hurt you. It doesn't cost that much. If you're looking to just get, having everything be taxed to you individually, form a single member LLC. But back to the question of forming a business bank account, what does it take? You need to have an EIN or a social security number and the business documents for the formation of that, for that entity. So that's how that works. All right. I have a services business in Texas. Is there a point at which I may make sense to convert to an S Corp from a tax standpoint? I plan on keeping my business small, no VC funding. If you're a services business, consulting and training, yes. And you actually don't need to convert. All you would need to do is make a tax election. And so you would just tell the IRS, I don't want to be taxed as a partnership. I want to be taxed as an S Corp. Make sure your accountant does that. That's an accounting thing that your accountant can file that with the IRS and do that. There are benefits to being an S Corp, that if you are a services business, as an S Corp, you will pay less self-employment tax based on the amount of money you make. So that's where an S Corp is beneficial. Again, S Corps don't work for high growth businesses because you can't raise money into it, but for a services-based business, it would work well. Is there a standard form PII online? Truly Go would have one. Also, Savvy, feel free to check out our platform. So what Savvy is, I'll take the opportunity here just to talk a little bit about Savvy. Savvy is a platform that provides automated templates for startups. So you get good legal templates for entity formation. If you're forming your business, if you are already formed your business and want to convert to a Delaware corporation, we have workflows and templates for that. We also store all of your documents and create what's called a data room. And so when you go to raise money, one of the things that investors are going to say is they're going to say, show us your data room. And what they're really saying is, show us all of your legal documents that you've done to date in one place. And so Savvy is a technology platform that will automate legal documents for you. We have PIIAs, we have option plans, we have stock options, we have founder documents, entity formation documents, we have investment documents. And you can go and automate a lot of that on the platform. And then you'd be able to make sure that all of those documents are stored in one place. And so we're giving you the ability and the tools to go to raise money and have everything in order and not have fallen into one of these legal pitfalls that we've talked about. So if you are looking for a PIIA, you can form an account on Savvy. You can form a free account on Savvy and poke around. We do have subscriptions based on usage and need. You can use a free account to form an entity, but then you might need to get on a subscription to do some more thorough or more robust documentation like team documents. But Truly Go offers some documents for free if you want to poke around there as well. All right. Let's see. What is the recommendation for equity splits when investors will be taking 20, especially when investors will be taking 20 to 30%? How do investors look at this split? So let's talk about founder equity and investor equity in kind of answering this question. So founder equity, one thing that a lot of founders don't understand is when you give equity to other people, let's say you're the main owner and you're going to give a co-founder 20% and you're going to give some other employee 3% and another employee 2%. And so at the end of the day, that means that you own 75%, your co-founder owns 20, and these two employees own 5% together. Well, what happens to that when you go raise money? And by the way, the split between founders, that's entirely up to you. It varies it could vary an infinite number of ways between how you split up equity between co-founders. It just depends on who's providing what value, and you have to come up with that determination with your co-founder. There are ways to determine that. Like there's a theory called slicing pie that you can Google that talks about how can you assign equity value to founders who contribute in different ways. I just recommend, come up with a split that feels right between you and your co-founder, that everybody's likes, and then get it documented from day one so that nobody can walk back down the road and say, oh, I feel like I deserve more. Because that's where disputes happen and companies fall apart. So come up with that founder split early on, document it. But then what happens when you bring on investors? So let's say an investor wants to come in and they're going to invest $1 million, and their expectation is, I want to own 20% coming out of that. So $1 million that gets 20%, that means your company's valuation is 5 million. So that's your post-money valuation is 5 million. Investors, the percentage they get is all about this valuation and about the money that they put in. So that's the math they're doing. I put in $1 million. If the valuation is 5 million, that means I get 20% of the company. How does that 20% get split up based on this existing founder cap table that is 75, 20, and 5? Well, the way it works is that doesn't come out of the primary founder's stock. A lot of times founders are like, well, that has to come out of my stock so that my co-founder stays at 20%. No, you shouldn't be talking about equity in that way. You own 75, they own 20, the other people own 5. And when you bring on an investor, you all drop. You all get diluted. That's what dilution is. It's not coming out of one person's equity. It's coming out of basically everybody's just dropping. Your number of shares stays the same, but you're issuing more shares to the investor. And so the denominator in your equity ownership calculation goes up. So the total outstanding shares is going to be higher because you just issued more shares to the investors. So that's something to keep in mind. Most equity rounds are going to be, if you're raising from a venture capital group, they're going to want to own between 15 and 25%. I'd say always try to push for 15. They're going to try to push for 20. You know, that's a pretty common range. 15 to 20 is the amount of dilution that you'll take for every venture round, give or take. Again, it depends on how much leverage you have, how successful you are, how attractive you are as an investment. If you aren't very attractive, your business isn't doing well, the investors may take a bigger chunk of flesh. 30% is a pretty aggressive investor take, but it's not unheard of. And it depends on how early you are. An investor who's putting in 500,000, you know, if you can justify a $5 million valuation, that's only 10%. But if they are pushing back and they get a $2.5 million valuation from you, you know, that's 25% that they're going to get. So that's the way that they're doing the math and how that they look at equity splits. And again, push valuation as high as you can. But when you need money, and so you take dilution where you have to.
Cool. So I want to be mindful of the time. You actually answered the last question I was going to ask, which is what is Savvy's offering for founders? Someone just popped in the Q&A. Could you compare the features of Savvy to AngelList?
Great question.
And we only have a couple of minutes, so go for it.
Yeah, so AngelList and Savvy are very similar in what we offer. At least Savvy offers everything that AngelList does. Plus, the way that where Savvy can distinguish itself is that if you have a custom legal document that you want to automate, the Savvy platform can do that. And so it is actually more of a transaction platform than a entity formation tool. AngelList has an entity formation tool. Savvy's platform is meant to be a life cycle tool that you can use for the entire life of your company. As you grow and you need more complex legal needs, Savvy can fit those in and they can automate those. And also Savvy can work with your attorney. And so if you have an attorney that you want to work with, Savvy is attorney agnostic, whereas AngelList is basically, here's some documents, you can't change these. That's kind of how AngelList works. And so that's the difference between Savvy and AngelList. Hopefully that answers that question.
That's great. We got 2 minutes. I don't know if you want to add any final comments or advice for our audience. We had some fantastic questions. You gave us tons of information. Where do we go from here, I guess would be my question.
Yeah, that's a great question.
Yeah.
You know what? One thing I want to emphasize is your journey as an entrepreneur is going to be bumpy and it's going to be a roller coaster. Do what you have to, be scrappy. As an attorney, my advice is just, hey, as you're being scrappy, just make sure that you're documenting everything from the get-go, because what the worst scenario that you can come across is you've been scrappy, you've done what you've had to get to the big inflection point where you can raise money or where you can get profitable. But to do that, you've made all these promises, equity promises or employment promises or salary promises. And now if you haven't documented all of that properly, you might, everything you've worked for might be undermined by somebody coming and saying, well, you have too much legal risk and liability for the fact that you didn't document everything properly. So that's something just to keep in mind, and do what you have to, but document it. And that's kind of my approach. Be scrappy, do what you can, and go get it. Be confident in yourself. You guys can do this. Maybe not your first try. Maybe it's, a lot of startups fail, but that doesn't mean that you as an entrepreneur are going to fail. You can, as an entrepreneur, are going to find ways that you can make a difference in the world, and find where that is. Where is it that you have knowledge or expertise or drive that other people don't, and go and take advantage of that.
Well, that's a fantastic note to end on. Thank you so much for the encouragement. Thank you for your wisdom, your knowledge. Folks, go look up the company. They sound like a winner to me. It's been my pleasure to talk to you, Dan, and to navigate these questions and hear from everybody. Our community thanks you, Start Out thanks you, and I'm definitely going to check out your website. And I hope everybody has a fabulous day. The recording will be on YouTube. Any last words? Maybe
Thanks
it's
so much,
goodbye.
everyone. Thank you, Cindy, for moderating. Thank you, Dan, for joining.
My
Like
pleasure.
Cindy mentioned, the recording will be on YouTube within a few days. Also, we'll send up a follow-up email with some more information about Savvy if you want to connect with them tomorrow. And thank you. Hope to see you at another event soon.
Thanks, everybody. Good luck.
Thank
Have a
you.
great night.